So today we are going to see Section 138 of Negotiable Instruments Act, which pertains to dishonor of check. Dishonor of check means the check returns unpaid from the bank. So Section 138 has following elements. Always remember, whenever you study the Bare Act, any section, you have to break it down into simpler sentences, right? In order to understand the components of the section. So what are the components of Section 138? Section 138, first of all, it must be noted here, constitutes the offense of dishonor of check. It penalizes the dishonor of check, although this is of civil nature, but it has been criminalized. It has been made an offense in order to make checks reliable instruments. So the first thing in Section 138 is a person draws a check drawn on account maintained by him. You can see on the whiteboard, maintained by him. So the account must be maintained by the person who is drawing the check. Let's say A has drawn a check of rupees 50,000. Payment is to be made to Mr. B. So the check must be of that account which A maintains, if that is already a closed account. Hence, the account stands closed on the date mentioned on the check. Let's say 13th of August 2020 is the date mentioned on the check. But before that date, the account was already closed. Then Section 138 will not be attracted. You may take the recourse to Section 420 of IPC, because a person drawing a check on an account which is not maintained by him, which is already closed by him, amounts to cheating, right? So if it was done intentionally with mens rea and actus reus, then obviously it is cheating, but it is not an offense under Section 138. So the expression maintained by him makes it very clear that it should be a live account. It should not be an account already closed before the date mentioned on the check, closed before the check was issued. Second important element of Section 138 is that it was drawn for the purpose of discharging a debt or other liability. So here you may see the ellipsis, means some missing expressions. Debt must be a legally enforceable debt. So when the statute says debt, it should be a legally enforceable one. Liability should be a legally enforceable one. There may be a debt which is already time barred. So if a check is issued to discharge a time barred debt, means where the Limitation Act has already put a bar on any remedy from courts, then dishonor of such a check will not attract Section 138. So for Section 138, it should be a legally enforceable debt, a debt that may be enforced by the court, right? So it should not be a time-barred debt, it should not be a time-barred liability. And the check must be issued for the purpose of discharging a debt or any other liability, a liability which is legally enforceable. If a check has been issued for charity or for giving a friendly loan to a friend and it returns unpaid, then Section 138 will not be attracted, because if you are issuing a check for charity, it is not for discharging any debt or other liability. But let me tell you here, some complexities may arise that we will discuss later. Right now, only the components of Section 138. And after that, we will do analysis on the basis of Supreme Court judgments. So it should be for discharging a debt or other liability. Third element is the check is returned unpaid due to any of the following reasons. So either it is because of insufficiency of funds in the account maintained by the drawer. The one who has drawn the check has maintained an account, but that account does not have sufficient money to honor the amount mentioned on the check. So insufficient fund, or sometimes between the drawer and the banker, there can be an arrangement by way of agreement that only a particular amount can be withdrawn on a particular day, right? So in a day, if there is a limit arrangement and that limit is already exhausted, hence the check got returned unpaid, then Section 138 will be attracted. So either it is because of insufficiency of funds or limit of withdrawal arrangement with the banker. Here, there was an interesting case in which the check was returned with the endorsement that account is closed. So here you will have to see that when was the account closed. If the account already stood closed before the check was issued, before the date mentioned on the check, then section 138 will not be retracted, something that is already clear. If the endorsement by the bank is stop payment, sometimes the drawer may, after having issued the check, stop the payment. Means they, the bankers will stop the payment if such an instruction has been given to the banker by the drawer. So if the endorsement on the check is stop payment, then as the Supreme Court has held, it will be considered as insufficient fund in the account or limit arrangement. It will be covered by section 138. So if it is because of the stop payment instruction given by the banker, then section 138 will be attracted. It will be considered as insufficiency of fund in the account. Then the fourth element is notice of dishonor is received by the payee, right? So the one who had deposited the check in the bank receives a notice of dishonor, receives the notice along with the check on which it is written insufficient fund or limit arrangement or stop payment. So you have to note the date on which the notice is received, because from that date, the countdown of 30 days will begin, within which the payee or the holder of the check must send a notice demanding payment from the holder, from the drawer, right? So a notice must be sent to the drawer demanding payment. And let me tell you, this notice must be a valid notice. The Supreme Court has laid down certain important conditions that must be satisfied with this notice. I'm just giving an example here. The cases will be dealt separately. Like, let's say the notice demanding payment also mentions the rate of interest, legal expenses, mental harassment, and all other things. Remember, now this notice is not a valid notice for the purpose of section 138. It won't attract the mischief of section 138 because here it is not a notice demanding payment of the amount mentioned on the check. Rather, it also mentions certain other sums that may become disputable, right? Here, anything that raises a dispute that the other party may dispute. Remember, if an amount is mentioned on the check, the other party cannot dispute that because it is already mentioned. It is signed by the drawer. But where some other amount is also mentioned in the notice, dispute may arise, and that should go to the civil court, which will adjudicate upon the dispute. Therefore, notice demanding payment should be the amount which is mentioned on the check, no other thing. If there is any other thing mentioned, that may attract the dispute from the other party, right? And the next element is the drawer fails to pay the amount mentioned on the check within 15 days of the receipt of notice demanding payment. So once the notice demanding payment is received by the drawer who had drawn the check, he has 15 days within which he must make the payment. If he fails to do so, then on the 16th day, means after the lapse, after the expiration of 15 days, the offense of dishonor of check is constituted and the cause of action arises. Now, the holder of the check may approach the judicial magistrate first class or metropolitan magistrate with a complaint. It is a complaint case, and this is only when these 15 days have lapsed. So the offense contemplated by section 138 is committed only after the expiration of 15 days of this notice period. So these are the elements of section 138. We will see more elements a little later.